a very topical issue right now in light of FTX's recent Chapter 11 filing, as well as what has been a big year in terms of crypto insolvency related issues, particularly with Celsius, Voyager, and of course 3 Arrows that has happened over the course of this year. For context, I am Adam Schnider. I'm an associate in the finance team here at Travers. I've also got some experience in restructuring and insolvency, as well as some special situations work. And personally, I've been active in the crypto space since about 2017. I'm joined by my colleagues. Firstly, I'll introduce Jonathan Gilmour, partner and head of derivatives and structured products at Travers Smith. He is a published author on digital assets and smart contracts and sits on various committees in the space and works with many UK and international crypto bodies on crypto initiatives. I've also got Peter Hughes, a restructuring and insolvency partner with a particular focus on derivatives and structured products, as well as digital assets. Amongst others, he acted for the administrators of Lehman Brothers International Europe in relation to a number of complex disputes. And finally, in front of me, I've got John Lee, dispute resolution partner with extensive experience in financial disputes, particularly in the Lehman fallout, and a published author in the crypto space. Right, so I think before we dive straight into the topic of insolvency in the crypto space, I think we need to back up a bit and go back to the basics. I'm sure many of our listeners might be familiar with the idea of crypto and blockchain technology, and that it was conceived to be to enable so-called trustless exchange of value on a peer-to-peer basis, without central intermediaries or exposure to counterparty/credit risk. So why are we even talking about insolvency in the context of crypto assets, John?
Yeah, I think the best ways to think about this is to look at crypto through 2 different lenses. The first is the technology that underlies it, so that's blockchain and distributed ledger technology. And secondly, crypto assets as a financial asset class. So you can be interested in one, but not the other, or you can be interested in both. But the essential point is that service providers in this space can offer clients exposure to crypto assets as an asset class, but they don't necessarily have to use the underlying technology or blockchain technology to do so. Instead, their operational models can largely mirror what we have in the traditional financial system, or indeed any other area of commerce, which is reliance on contractual obligations and credit and risk management, which requires human judgment and so on. So this is often called CeFi, short for centralized finance. Now, this is in contrast to decentralized finance or DeFi protocols, which use, for the most part, irrevocable automated smart contracts deployed on blockchain ledgers, which are based on conditional logic and full collateralization, which are intended to make transactions less susceptible to traditional risks like counterparty default and insolvency. So, for example, many centralized crypto exchanges require users to deposit their crypto assets with them, and thereby they relinquish self-custody of those assets and then take on the counterparty risk of the exchange keeping those assets safe and the exchange remaining solvent. I should say that actually none of this is to say DeFi is better than CeFi or anything like that. Each have their own pros and cons, as does the traditional financial system itself. So, for example, DeFi protocols by design rely heavily on smart contract code, doing what the parties intended, free of bugs and unforeseen consequences. They're also susceptible to hacks, which might leave victims with limited ability to recover the stolen assets. So rather than risk being eliminated, it is just shifted to a different place. There are also generally issues around scalability and efficiency in relation to DeFi, given that essentially all material moving parts of the transaction need to be, quote, self-contained within the relevant smart contract. But coming back to the original question, whatever the subject matter of the transaction might be, whether crypto or not, if you are relying on traditional natural language contracts and counterparties fulfilling their obligations, then you obviously can't completely eliminate risks that are inherent with those arrangements, like default and insolvency.
Thanks, John. That's a really helpful explanation, and I think it's a great backdrop to now drill down into the kind of purpose of us getting around a table today, which is really to discuss the matters around FTX and the Chapter 11 filing, which I'm sure our listeners are very keen to hear more about. So we obviously know that FTX filed for Chapter 11 on the basis of cash flow insolvency, and according to recent journalist reports, it appears that they're also balance sheet insolvent. In this or any other similar situation, understandably, customers, depositors, creditors, and investors want to know how much they're likely to recover from whatever is left of the insolvent estate, if at all. Given the likely shortfall there is going to be, clearly a key battleground will be establishing the priority of distribution between the various creditors. And on that question, an important issue will be determining the nature of the rights and interests various creditors have. And in the case of FTX, like many other centralized exchanges, they provided a number of services, including crypto trading, spot crypto trading, spot fiat trading, futures and other derivatives, as well as margin trading and so on. Jonathan Gilmour, would you be able to talk through the differences, if any, in the respective rights of customers who engaged in those various services?
Sure, Adam, thank you. Yeah, so from an English law perspective, and I note that the terms of business of the non-US FTX business is stated to be governed by English law, a potentially significant point is the proprietary nature of crypto assets. It's now reasonably clear that crypto assets are a form of personal property under English law, but there's still some uncertainty around the precise nature of that property right, and many of these issues are currently the subject of a consultation by the UK's Law Commission on Digital Assets. So relevant to our discussion, the Law Commission currently considers that crypto assets are capable of being subject to a trust under a custody arrangement. And what that means is that crypto assets may be held by or in the name of a custodian, which could be an exchange, but the beneficial or equitable interest in the asset remains with the depositor. This is potentially very significant because if such a trust exists and those trust assets are identified, under English substantive as well as insolvency law at least, those assets belong to the depositors and they'll be separated from the pool of assets that will be divided up amongst other creditors. So it's possible that customers who deposited or bought spot crypto assets will have retained proprietary interest in those assets, whereas those with fiat balances or who entered into derivatives contracts might only have unsecured contractual claims against the general estate assets. But in the absence of both very clear terms regarding custody and practice consistent with those terms, there's likely to be uncertainty as to whether that is the case, or in fact, even those with spot crypto asset balances only have a contractual claim for the value of those assets.
Yeah, I agree with that, Jonathan. And even if you could establish that there was a trust in the first place, it might not necessarily be straightforward to actually identify those assets as separated from the general, quote, house assets of the insolvent estate. So, for example, the trust assets may have been commingled with the house assets, or they could have been transferred to third parties. Then you really get into the potentially complex and knotty questions around tracing of those assets, and that's both legal and factual, through the hands of third parties, as well as identifying the proceeds of those assets. And there are also defences which could defeat those proprietary claims, like a bona fide purchase for value without notice of the dissipation of the assets in breach of the trust. And even if there is a shortfall, even for those with proprietary rights in crypto assets or their proceeds, there is also uncertainty about how that should be accounted for. So, for example, is it done on a pro rata basis, or is it done on a sort of first in, first out basis, or something else? Now, we do have specific legislation for investment banks in a non-crypto sphere. So that's the Investment Bank Special Administration Regulation 2011, which were introduced in the aftermath of Lehman, and the significant delays in the distribution of client assets in that administration. But we don't have anything at the moment specifically for crypto assets. And finally, and to the extent that those proprietary rights fail for whatever reason, then the customers would be left with general unsecured claims like everyone else and join the others in the queue.
Sure. I mean, that's understood. And I know we've been hearing about distributions to certain customers prior to Chapter 11 filing, but not others. I think particularly in the case of certain customers in the Bahamas that were allegedly able to access their accounts prior to the formal filing, which has subsequently been denied to have been authorized by the Bahamian regulators. So there are clearly cross-border angles to this, but I mean, from an English law insolvency perspective, they are surely susceptible to challenge.
Yes, I mean that is right. So if we looked at this as if this were purely an English law situation, then yeah, you'd be engaging various bits of our insolvency legislation that have teeth to claw back transactions like that. So here, it would be the rules around transactions at an undervalue, it would be the rules around preferential transactions, and the rules around transactions defrauding creditors. Now, given what we've got with the FTX fact pattern, I think it's what we're really going to be looking at is going to be the US bankruptcy code equivalent provisions and the local law, potentially the local law provisions in Antigua as well, where well, actually it's more than that, but where those key entities are based, where the holdings are. But so, for example, taking the US bankruptcy code, they've got equivalent provisions there. So it's all going to depend on the specific facts, the transaction, but I would expect that the bankruptcy trustee is going to be taking a very close look at all of the transactions, and clearly the ones we've been talking about rather bury the needle, don't they? But there's been an awful lot of transaction, and the look-back periods are long. So that's going to be a complex and time-consuming but very important part of the case. So huge area of focus. And yeah, we've got, I mean, in addition to the concerns around the which I think maybe they turned out was just bad reporting. There was the concern that the local authorities had actually allowed locals to remove assets. There's a lot of concern around that. But we've also now got reports of this sort of wholesale hack they've had as well. So clearly a lot of assets have moved, and that's going to be a big focus for the trustee of banks.
Cool. So I mean, it's thanks, Peter. I mean, it sounds to me then that that there's seriously a huge cross-border nature relating to this insolvency, and it sort of makes sense with a customer that with an entity that has serviced customers all around the world. But I think drilling down at the facts we know thus far, I mean, we've got a the sort of non-US business side. So this is leaving our FTX US for the purposes of this conversation. We have an Antiguan contracting entity with a Bahamian service provider with terms of business governed by English law and a Singapore arbitration clause and a Chapter 11 filing on behalf of virtually all of the 100+ companies in the FTX group. I mean, John, how do you see this all playing out?
Yeah, so as you mentioned, so for the vast majority of customers who don't have bespoke contractual arrangements, then yeah, the terms of business will be the starting point for them. But that said, we know that most people don't read the small print when they use online services. And in the UK, at least, there is specific consumer legislation in place which allows consumers to challenge things like limitation of liability, but also potentially governing law and jurisdiction clauses. So it may be possible for consumers in England, and consumers, that's broadly speaking, people who don't invest or trade crypto assets as a living, to be able to bring claims in England, as opposed to, as the term states, arbitration in Singapore. And to complicate things further, as you alluded to, there's this overlay with cross-border insolvency proceedings. We saw in the aftermath of Lehman and other cross-border insolvencies in the past that there are likely to be jurisdictional battles ahead, with different national courts potentially trying to assert jurisdiction over the same issues. So, for example, as I mentioned, certain creditors may institute proceedings in, say, England, but the estate or other creditors might say, no, they should be brought in the US because that's where the seat of the Chapter 11 insolvency proceedings are. So we might well see parallel proceedings and even conflicted judgments in the times ahead.
Oh, thanks, John. I mean, just building on that a little bit more, I think another angle to think about here is the duty of the trustee in the bankruptcy process. I mean, I guess there are two things that come off that. Firstly, the fact that many of FTX's assets appear to be held in crypto assets, which are volatile, as well as in certain cases illiquid, as we saw from the sort of balance sheet that's been published. And I think the second point is the potential use of DeFi protocols and smart contracts, which might not necessarily be capable of being overridden by the trustee for the reasons you set out earlier in your introduction. I mean, Peter and Jonathan, what are your thoughts on those points?
Yeah, well, the trustee in bankruptcy is there's going to be a lot to do, and this is going to take a long time. But everyone's, I think, sensible guess on this. The trustee's job is to maximise what he and his team can get in for the value of the bankruptcy estate. So that's their jumping in. But conversely, they are not in the business of taking market risk. So a significant central concern for them is going to be how they deal with all this volatility that it's happening as we speak. We're seeing the price on these coins is switchbacking, or frankly tanking in many cases. So they're going to want to achieve this maximisation of return within sensible parameters. So there's going to be a constant balancing exercise between reducing the market exposure, because they're not in it. They won't be. The downside for them of a huge loss that they voluntarily shoulder outweighs the upside for them of some unexpected crypto gain, frankly. Right? So they're going to want to reduce their market exposure, but they're going to want to get the best available price for the assets that they're liquidating. So that's the overarching kind of the golden thread. But in practice, that is just going to boil down to, no doubt, hundreds of different conversations about different asset pockets that they've got, different conversations, different things at different places. I mean, but we're talking about that FTX ledger, right? It's like the back of a fag packet with just a few balancing. You can be sure when you get in on the ground, it's more complicated than that.
Yeah, for sure.
So on the ground, it's going to be massively complex, and they'll start with the easy wins. There will be some stuff that they've got, in their accounts. They've got control of it. They've got the keys. It's actually valuable. They can liquidate it to fiat or something, something that they're not worried about the value slip on that. Those are the easy wins. But then, kind of in many ways, the interesting bit starts as they move through the rest of the asset classes they've got and the holdings, the difficult areas where stuff isn't liquid or it's not within their direct control, it's within subsidiaries who maybe aren't responding to the Chapter 11 in the way that they like, because of the kind of stuff that John was talking about, different jurisdictions fighting with each other, all that good stuff. And then, what if they can't locate the assets? There's tracing they're going to have to do. And then right the way through, as we've already talked about, to clawback, where actually stuff has left the estate and shouldn't have left the estate, and they want to get it back and then again turn that into cash. So lots and lots of different conversations there. It's going to grind out for a long time.
Yeah, and certainly DeFi protocol and smart contracts are like to raise difficult and novel questions around the duties of trustees and also reviewable transactions. And typically you make a commitment to a DeFi protocol by locking up crypto assets, and the smart contract just runs its course automatically and without any further human interference during its term. Crucially, some of these transactions are irrevocable, so you can't unilaterally terminate them. This is how, as John mentioned before, these protocols seek to eliminate counterparty risk. But the flip side in an insolvency context is, of course, that the trustee in bankruptcy might not be able to liquidate those assets straight away. And during that time, they would certainly take on market risk of the value of the assets and also technical risks in relation to the proper functioning of the DeFi protocol. It's also unclear whether these types of transactions would be subject to review if they were entered into prior to the relevant look-back periods. Even if they could be challenged, there's also the practical challenge of finding out the identity of the counterparty and seeking recovery of assets from them, because the very nature of trustless DeFi protocols allows parties to transact without even knowing the identity of your counterparty.
Sure. Thanks, Peter and Jonathan. I mean, I think just on that as well, if I'm understanding things, some things correctly, I mean, people were able to sort of trade, on FTX without necessarily have completed their sort of KYC processes, and then not being able to remove any assets off there until such time as they actually completed that. So if you're dealing with a particular account that has no KYC process, you don't know who that relevant person is. I mean, it's going to be very difficult to sort of figure out who owns what or what rights they even have. So I think, to sum up, there are generally a lot of really interesting and novel issues that are likely to arise out of this insolvency, ranging from the nature of proprietary rights and crypto assets held on exchanges, priority of claims, cross-border and conflicts of laws issues, as well as issues relating to DeFi protocols and smart contracts. I think we will definitely be following future developments on this with great interest in the days and months ahead. So thank you all. Thank you, John, Peter, Jonathan, for your insights, and thank you all for listening, and until next time.